Good afternoon, and thank you for joining us here today for this year's final installment of our webinar series on employment compliance in government contracting. Today's program is going to focus on prevailing wages and benefits under the Service Contract Act, as well as providing a brief compliance look ahead for 2020 going into the new year. My name is Matt Kissling, and I'm an associate in Thompson-Hines Labor and Employment Practice Group, where I primarily focus on advising government contractors and subcontractors on all aspects of employment-related obligations under federal, state, and local laws and regulations, as well as defending contractors during audit and compliance proceedings before the Department of Labor. Again, today's webinar is going to provide an overview of a government service contractor's compliance requirements under the Service Contract Act. Our discussion is going to include an assessment of your prevailing wage and fringe benefit requirements for covered service employees. We'll also discuss a number of pitfalls and consequences that can result from noncompliance and give some recommendations to ensure that you are satisfying all of your compliance obligations. Towards the end of today's program, we'll shift gears and conclude the program with a forecast of what to expect from the Department of Labor in 2020, as well as outline steps that you should be considering to make sure that you're compliant going into the new year. Before we begin, we do have some preliminary notes about the materials and technology that we're using today. Today's program is being recorded and will be available on Thompson-Hines' website. Questions will also be addressed at the end of the program. Each of you should have a side panel in the webinar here today, including a questions pane. So I would just ask that any questions during the program, you could please submit them using the question box on that side panel, and then we will address them, answer them at the end of the program today. Our presenters will try to address all questions, but due to time restrictions, we may not have a chance to get to them all. If we're not able to directly address everything during the program, we'll be sure to follow up with you directly with your question. I'm also joined here today by Joe Berger, who is counsel in Thompson-Hines Government Contracts Practice Group based in Washington, D.C. Joe has extensive experience in all aspects of government contracts compliance, including matters under the False Claims Act, which can come into play when dealing with employment compliance issues. And Joe will be touching on that a little later during the program today. Just again, a quick disclaimer for this webinar. This is intended to provide educational information to you about matters of legal interest, but is not intended as legal advice or to establish an attorney-client relationship with Thompson-Hines. If you do have any questions about the materials presented today, please do not hesitate to contact Joe or myself or any other member of our employment or government contracts practice areas. So the topics we are going to cover today, again, we're going to start with the Service Contract Act. It's initially going to provide an overview of the Act, as well as some tips for how you can determine whether or not your organization is covered. We'll then jump into an overview of wage payment, fringe benefit, and other compliance obligations under the Service Contract Act. And we'll wrap up with a discussion of some common SCA pitfalls, as well as consequences for noncompliance, as well as some tips for you to make sure you don't fall into one of those traps or otherwise fall out of compliance with your obligations. And then again, we'll change gears and do a brief look ahead to 2020. This is going to focus on the OFCCP's enforcement activities in 2019 and going into 2020, as well as some expected changes from the agency. We'll also provide a refresher on your obligations as government contractors and the required reporting and record-keeping obligations to make sure that you're in a good position moving forward into the new year. So without delay, let's first jump into the Service Contract Act and talk about some of the basic coverage issues. So the Service Contract Act does apply to all government contracts, the principal purpose of which is to provide services in the United States through the use of service employees. The Department of Labor considers a principal purpose to be a simple majority of the contract work. So at least 50% of the contract value or the workforce used is for covered service activities. That's what's required to then bring the contract itself within the Service Contract Act and its related requirements. Now, from a financial threshold perspective, it is very easy to meet. It's $2,500. It's essentially been the same threshold since the Service Contract Act was first enacted decades ago and really has not been changed. There has been some discussion in Congress as as well as in the administration about raising that threshold, but to date that has not taken place. So 2,500 is still the magic number to keep in mind. And another important thing to remember is that if you do business or you have locations in Washington, D.C., the SCA applies to any contracts with DC's local government, since the local government there is ultimately answers to federal Congress. So while the SCA typically only applies to federal service contracts, the exception is made in the District of Columbia. Another important thing to remember is that if you are a prime contractor or you're a subcontractor and do work related to an ultimate government service or product, the SCA could apply to you because the coverage does flow down to any subcontractors used to complete the ultimate government contract. And this does flow down to the nth degree. So you could be a subcontractor third or fourth down the chain from the direct contract, and that means you could still fall within the SCA's requirements. Now, from a coverage perspective, again, the definition is very broad, and the regulations for the SCA do provide a number of different examples of what they consider to be qualifying services. Here are a few examples here that we typically see are cafeteria and food services, data collection, processing, and analysis, landscaping and grounds maintenance. So you provide these types of services in a federal park. The SCA is something you'll need to think about. Maintenance and repair of equipment. So if you don't supply the equipment, or you do supply the equipment and then provide a separate contract for repair services, that could be something that would fall within the SCA's coverage. Then it can even extend to property management and parking services. And I mentioned before that the regulations list a number of examples. They illustrate about nearly 60 different types of covered services. Some other ones to consider, since we're getting close to the holiday season, the related foul weather, snow removal is something that would be considered, or even providing support services at military bases, and doing other things such as vending machine services or visual and graphic arts. Those are all types of services that, if it's related or is done for the federal government, are something that would be considered qualifying for SCA coverage. The SCA does exempt a number of other types of contracts, most importantly a federal construction project. So if you are under contract with the federal government to provide construction or building rehabilitation services, the SCA is not something you probably need to worry about. Instead, you would be subject to the related Davis-Bacon Act prevailing wage and fringe benefit requirements. Other things that aren't covered are supply contracts, subject to the Walsh-Healy Public Contracts Act. So if you have a contract to provide a product to the government, that's not going to be covered by the SCA. Instead, Walsh-Healy will apply. The important thing to remember there is that I mentioned before, if you also provide a related contract to service the equipment or the product that you provide to the government, those services that you provide could fall within the act, but your actions of actually supplying the product would not. So there could be a split coverage issue for that type of an arrangement. Other contracts that don't apply are transportation of freighter individuals where tariff supply, public utility services contracts, so electricity, water, or gas, contracts for providing services that are covered by the Telecommunications Act, and then contracts for professional services that are performed almost exclusively by employees who are considered exempt under the Fair Labor Standards Act. So these are the types of contracts that we see that would not be covered by the SCA or subject to any of its requirements. So the next question is, if you provide a covered service, what employees are going to be subject to the SCA? And I mentioned, and the important thing to remember here is that any non-exempt employee who works on the SCA covered contract is going to be considered a covered employee. Again, these contracts can include a number of different professional services and individuals performing those services under the contract. And the focus here is really on the job function and the method of compensation that's provided to the employee. So I mentioned before that exempt employees are typically not covered to the SCA. So if your workforce falls into any of those traditional categories, such as executives or managers, administrative professionals, computer employees, creative professionals, or outside sales individuals, these are all employees who are not going to be covered by the SCA, and so you won't need to provide them with prevailing wages or any of the fringe benefits that we're going to be talking about in a few moments. Since the coverage issue is always a hot topic, not only for SCA but also for FLSA, overtime issues. It's always a good opportunity to make sure that you're properly classifying your employees. And because if you don't, the penalties can be severe from both an SCA and an FLSA perspective, and it's something that the Department of Labor loves to go after employers for. So if you have any questions about whether or not your employees are classified properly, the recommendation would be to reach out to your outside labor and employment counsel and have them conduct a review of your current classifications. So once you've worked with your employees and you think you might be covered by the SCA, how exactly do you confirm that? The most obvious way to do it is looking for the wage determination with the contract, where the wage determination is something that is issued by the Department of Labor and is supposed to be included, and I use supposed to be in air quotes. It's something that's supposed to be included and incorporated into the contract, either by the federal agency that issues the contract. So if you have a contract with the Department of Energy or the Department of Defense, they're supposed to be including this wage determination in your contract. Or if you are a subcontractor, the subcontractor or contractor above you in the chain is supposed to include it in your subcontract as well. Now, the important thing to remember here is if the wage determination is not in the contract, you're still expected to comply with the prevailing wage requirement and fringe benefit requirements, and the Department of Labor will enforce the SCA even if the wage determination is missing. It will mitigate any potential penalties or consequences of non-compliance, but at the end of the day, the Department of Labor expects anyone doing this type of work to be aware of their obligations and not rely solely on the presence or absence of the wage determination. With that said, if the wage determination is not there and you have other questions about how or whether or not you're covered, the next thing to look for would be the FAR clauses in the contract itself. And these are the contract provisions from the government that specifically invoke the SCA's coverage for a particular agreement. So look for FAR 5222-41, the Service Contract Labor Standards, or these two other provisions, 222-43, which involves a price adjustment for FLSA and service and SCA standards, or 222-44, which is another price adjustment clause in the FAR. So if, let's say, the FAR clauses aren't there, what are some other indicators that your contract may be subject to the SCA? And the next thing to look for is, does the contract itself and the language that you receive, does it reference the SCA or the regulations found at 29 CFR Part 4? So some things to look at are such statements as, this subcontract incorporates by reference the provisions of 29 CFR Part 4. That's a pretty good indicator that the contractor above you is subject to the SCA and considers your services to them to also be covered by the SCA. Another thing to look for is a more explicit statement that this subcontract and all work performed is subject to the wage and fringe benefit requirements of the Service Contract Act. If you see that kind of language, that's a good indicator to you that you should then go looking for the wage determination and make sure that you are properly classifying your employees and paying them the necessary wages and benefits. And I mentioned before, if the wage determination is not in the contract, there is a website that you can go to that has all potentially applicable wage determinations listed. It's wdol.gov, and it contains a database of all currently active wage determinations across the country for individual localities where you're performing the work. So with all that said, if at the end of the day you just determine that your work is covered by the SCA, what are the things you need to worry about? And this is really falls into three different buckets. Prevailing wages and fringe benefits are the main areas, and there are a few other obligations that you'll also need to worry about and that we're going to discuss here today. So at the starting point, the prevailing wage requirements are really the baseline for complying with the SCA. And what they are, they're set forth in the wage determination. They set the required minimum hourly rates for all classifications of work performed on the contract. Now, there's nothing that prevents you from paying the employees in excess of those minimum rates, but you should keep in mind that there are certain equality considerations for employees in the same position or classification. So if you have two employees working in the same job, performing the same duties, they should be getting paid the same hourly rate for their SCA covered work. Now, if you have someone who's in, let's say, an operator position, they have another individual who's in a lead operator position, that may be a situation where you could pay the lead operator at a slightly higher rate than the operator, given any additional responsibilities that go along with being a lead. Now, the minimum rates do need to be paid on an hourly basis. This can be done by salary or through bonuses or any combination of compensation. At the end of the day, you do need to hit the minimum hourly rate specified in the wage determination. And you also need to document all hours worked and rates paid for each covered hour on the contract. This is where the SCA is similar to the Fair Labor Standards Act, where for any non-exempt employees, you certainly need to keep records of all hours worked and hourly rates paid for each hour that the employee works for you, both straight time and overtime. And this is an issue we commonly see that arises whenever there's improper classifications for exempt versus non-exempt, where if someone was improperly classified as exempt, their hours were not being tracked by the employer, and then that can lead to a whole series of headaches and issues with the Department of Labor during an investigation or an audit. So from a prevailing wage perspective, here are a few examples of what to look for in the wage determination. So let's say you have employees who are in an administrative support role. They're going to be different levels of the specific position at issue. So accounting clerk 1, accounting clerk 2, or 3, each of which are paid at a different hourly rate. Obviously, the accounting clerk 3 is considered to be a more senior experienced position to the accounting clerk 1, and so that's what would explain the higher hourly rate. And similar for services and support occupations, you'll see a number of different positions listed there. Here are cleaner vehicles and janitor, each of which have a specified minimum rate that they need to be paid. I bring these examples up, and I mentioned classification before because the starting point for prevailing wage compliance is making sure that all of your covered employees are properly mapped to an SCA labor classification that's listed on the wage determination. So your accounting clerk 1, 2, or 3, or your cleaner vehicles, or your janitor. Each position needs to be specifically tied to one of those classifications on the wage determination. You can't have any split classification duties or create new classifications. So you can't have a position that is assigned to two separate classifications for 50% of the time or 50% of the work performed. At the outset of the contract, each position needs to be properly mapped to a single classification. Again, the focus here is on, similar to exemption status and coverage, is on function actually performed by the employee and then how it matches with the appropriate classification. Unfortunately, you don't have to do this blind. There is a directory of occupations out there that provides each of these classifications and then a description of the kinds of duties that would fall under that particular classification. So a good example here is, let's say you have an employee whose title is customer service supervisor. They're non-exempt, and they have these following job duties of overseeing and assessing customer service staff activities and providing them with regular performance-related feedback, assisting customer service staff with duties when required, investigating and solving customer service complaints, and maintaining documentation pertaining to customer service department activities. If you flip over to the directory of occupations, there are three different classifications of customer service representatives. There's a CSR1, which the directory describes as receiving, comprehending, providing, and responding to routine inquiries and service requests through the use of various communication technologies. A CSR2, which is responsible for performing the duties detailed in the CSR1 description, as well as being responsible for responding to escalated and more complex inquiries on a broader scope of topics. And finally, CSR3, which is responsible for performing the duties detailed in the other two categories, as well as being responsible for supervising and advising both the CSR1 and CSR 2. So based on the duties we saw here, which classification do we feel would be the best one for customer service supervisor? In our mind, it would most likely fall under customer service representative 3, because the supervisory position is, it's responsible for, all these, service staff activities and assisting in those duties, but it's also responsible for supervising the other customer service staff in the performance of their duties. So from an SCA classification perspective, you would want to slot that position into the CSR 3 and pay the corresponding minimum hourly rate that's described in the wage determination. So let's say you have a position that does not match any of the classifications that are listed on the wage determination or the Directory of Occupations. Fortunately, the SCA does provide you with some relief here, and it's called the Conformity Process, where there's not a spot-on match to a particular classification. The Department of Labor does allow you to request a conformance from them for that particular position. Again, this is only allowed if there's no other classification that covers the duties. And the conformance process then permits you to set that unclassified position at a wage rate that is similar to the wage rates for comparable positions that are described in the wage determination. Again, the focus here is on the skills required and the duties performed. And what you must do is you must present the proposed wage rates for the affected employees, and then actually submit it to the Department of Labor for approval. And once you do that, then the DOL will typically send you a letter either accepting your conformance and approving it, or telling you didn't do it correctly and asking you to resubmit it. And if they approve it, then you're safe to include that conformance with the contract, maintain records of everything, and then pay those employees at the rates that were approved by the Department of Labor. So we've mentioned your prevailing wage requirements. Let's shift gears to the types of fringe benefits that you have to worry about under the SCA. First, it starts with holidays, where the wage determination actually specifies the number of required paid holidays per year. There are both specific holidays as well as a few floating holidays as well. And the specific holidays are New Year's Day, MLK Day, Memorial Day, Thanksgiving, and Christmas Day. The kind of your typical holidays where offices and workplaces are closed. You can also substitute one of those listed holidays with a different paid day off, as long as that's communicated to employees in writing. So if you want to give your employees off for Columbus Day as opposed to MLK Day, that's something that you can do and substitute out, as long as it's notified to your employees in writing. And the important thing to remember here is any covered employees are generally only entitled to the paid holiday if they actually work during the holiday week. But if the employee is on vacation or leave during that holiday week, they still must be paid or given a substitute holiday for the day that they miss while on vacation. So we mentioned vacation. The wage determination will outline the amount of required paid vacation for any covered employees, and this is based on an individual's years of service. So here's something we typically see in a wage determination, where it's 2 weeks of paid vacation after 1 year of service with the contractor or successor, 3 weeks after 5 years, and 4 weeks after 15 years. The thing to remember here is that length of the service does span a period of continuous service with the present contractor and successor, wherever employed, and with the predecessor contractors in the performance of similar work. So if you assumed an SCA covered contract from another company and hired some of that prior company's employees to continue their work on the contract, their seniority does not restart when they switch over to your payroll. You'll be expected to honor their years of service and pay them the vacation that's described in the wage determination based on those years of service. The other important thing to note here is the entitlement only kicks in once you hit the particular anniversary date. So in this situation here, it says 2 weeks paid vacation after 1 year of service. So an employee who has not worked for you for a full year is technically under the SCA not entitled to any vacation benefit. If they work for you for 366 days, then they'll have 2 weeks of paid vacation, and then they won't get bumped up to 3 weeks until they hit their next anniversary date. Another important thing to remember here is that there is no use it or lose it permitted under the SCA. So any vested vacation, it does need to be used or paid out before the next anniversary date, the completion of the contract, or the termination of employment. So if you have an employee who hits their 1 year of service and they get their 2 weeks of paid vacation, if they're terminated after 18 months and haven't used a single day of that vacation, they need to be paid out for those full 2 weeks upon their termination date. This is where the SCA is similar to a number of state and local wage payment requirements that treat earned vacation as essentially wages that need to be paid out upon termination. The SCA does the same thing here. It's just from a timing perspective, it's just a little bit different, where it doesn't necessarily follow a calendar year for payout or vacation accrual. Instead, it looks at the anniversary date. But at the end of the day, they're terminated before the next anniversary date. They need to be paid out for any unused vacation. Similarly, if they reach their next anniversary date, so their 2nd year of service, and they haven't used any of their 2 weeks from the prior year, they would need to be paid out or allowed to roll over that vacation to the next year. So another thing you have to worry about, this is something again where the SCA is similar to a growing number of states and localities, is a requirement for paid sick leave. And this was Executive Order 13706, which was signed by the Obama administration. It applies to any SCA covered contract that was awarded or renewed or modified on or after January 1st, 2017. Now, the Department of Labor has updated all its wage determinations to include this paid sick leave requirement for any contracts that are created or renewed or modified after that date. And we've also seen that the contracting agencies, so like the Department of Defense or the Department of Energy, are proactively taking steps to modify existing contracts to make sure those sick leave requirements are incorporated. What the executive order does is it requires at least 56 hours of paid sick leave per year, which is earned at a rate of 1 hour for every 30 hours worked. And it can be used for a specific set of reasons: the own illness or health care of the employee, illness or health care of an employee's family member, or certain reasons related to domestic violence or stalking. So a good example there would be an employee who needs to go to court to obtain a restraining order as a result of domestic violence, or are called to testify in a trial related to domestic violence, or to seek counseling related to domestic violence or stalking. Those are all reasons that would be covered by this paid sick leave requirement, and would be a reason why an SCA covered employee would be entitled to use some of their paid sick leave. Another important thing to remember here is that unused sick leave does carry over to the next calendar year, but it does not need to be paid out at termination. An important thing to remember here is this could present some conflicting obligations under state and local paid sick leave requirements, where if you're an SCA covered contractor, but you also do business in, let's say, the state of Washington, the SCA sick leave requirements is essentially the floor, the minimum. If you're in a state that has more generous paid sick leave requirements or carryover requirements or payout at termination requirements, you would be expected to apply that more generous requirement to all of your employees, including those covered by the SCA. Now, what the SCA says is that if you have an existing PTO policy, you can meet these paid sick leave requirements if you not only provide sufficient PTO to cover both paid sick leave and the separate SCA vacation requirement, but you also allow the PTO to be used for any of the executive order's required purposes, and you also satisfy the minimum accrual requirements and allow unused PTO to carry over from year to year. Now, obviously, if you do business in a number of different states and have a number of the different obligations in place, creating a single uniform PTO policy can be a bit difficult. So one of the things that we've seen is a lot of organizations are essentially amending your existing PTO policy to create specific carve-outs for employees who work in those states or localities, and there's no reason you couldn't do a similar thing for any SCA covered employees who are entitled to paid sick leave under the executive order. So it does require some work with your existing policies, but it is something that can be accomplished. You can kill 2, 3, or 4 or 5 birds with one stone with a single policy. So the final benefits requirement under the SCA are this concept of what's called the health and welfare benefit. Again, this is something that's described in the wage determination. It requires a minimum hourly rate of health and welfare benefits to be provided to covered employees. The current requirement is a minimum of $4.54 per hour. If you're subject to the paid sick leave requirement, then your minimum hourly rate is $4.22 an hour. And an SCA contractor is required to satisfy these obligations through cash payments outside of wages at the specified H&W rate, providing bona fide fringe benefits, or providing a combination of both. So the logical question is, what the heck is a bona fide H&W benefit? The Department of Labor considers these to be a legally enforceable obligation that's specified and communicated to employees in writing, is not otherwise required by law. So providing mandatory state paid sick leave in the state of Washington would not satisfy the H&W requirement. They must provide for payment of benefits on account of death, disability, retirement, medical expenses, unemployment, or other reasons. And there must be a definite formula for calculation and must be paid irrevocably to a trust or to a third party. So with this definition, the Department of Labor has kind of laid out what it considers to be compliant benefits and non-compliant benefits. So paid sick leave that's provided in addition to any leave requirement by the executive order or state law would be considered an H&W benefit. Contributions to a pension or 401k plan, excess vacation or holiday benefits that that go above and beyond than what's required by the SCA, health, life, or disability insurance contribution, and other forms of paid leave such as jury duty, bereavement leave, or paid parental leave. Things that the Department of Labor does not consider to be compliant would be payment of relocation expenses, any incentive awards, reimbursement for tools or uniforms, statutory employer payments. So for FICA, state unemployment, or workers' compensation, those are all contributions that, again, are required under state law, or payment of disability insurance or family leave insurance if required under state law. So if you do business in the state of New York, where you have mandatory state disability insurance and paid family leave insurance requirements, you wouldn't be able to use those to satisfy the health and welfare obligation under the SCA. Another thing that's important to remember here is when you look at this $4.54 an hour, what the Department of Labor is working for is what are you as the employer paying out of pocket to provide these benefits. It's not the value of the benefit being provided to the employee and what they're receiving, it's the amount that you are paying for these benefits, whether it's as a cash, a fringe benefit, or a combination. So you got to look at your out-of-pocket costs for providing these benefits when you're measuring whether or not you're complying with the SCA. As if this isn't complicated enough, there's also some interesting nuances presented by the wage determination itself, where yes, there are odd numbered and even numbered wage determinations, and the numbering that you have does make a difference for an H&W requirement. So if you have an odd numbered wage determination, you have what's called a fixed cost of health and welfare requirements. This is really the traditional health and welfare obligation, where you must give the minimum hourly rate in H&W specified in the wage determination to each employee. Again, that's currently $4.54 an hour or $4.22 if you provide the mandatory paid sick leave. And you must pay the H&W rate or provide the H&W rate for all hours paid up to 40 hours per week. So this includes any vacation time or paid sick leave or other paid time, that's not non-working during the week, but it excludes overtime. Now, if you have an even numbered wage determination, this follows what's called an average cost formula for H&W benefits, where the total health and welfare given to all covered employees during a particular pay period must average at least the H&W rate in the wage determination. So if you have 5 employees who are working on the covered contract, the amount of H&W that you give to those 5 employees in total must average at least the $4.54 an hour set forth in the wage determination. So it requires a bit more math here. Some other differences is that it's calculated for all hours worked per week, including overtime. So if you have an employee who works 50 hours a week and gets paid 40 hours for straight time, 10 hours overtime, you calculate the H&W for all 50 of those hours worked during the week. But the even numbered wage determinations excludes any paid non-working time. And if you do your math and you find that your average H&W that's provided is less than the specified required rate, then you're required to then provide equal cash payments to all employees to make up the difference and to reach that specified hourly rate. So again, I mentioned, that it does require some complex, math calculations here, but it is something to keep in mind. I will say the even numbered wage determinations are relatively rare. We don't see them all that often, so you're most likely going to fall under an odd number, but you should, one of the important things to keep in mind when you're looking for your wage determination is to look at the number, so then that'll determine what you need to do to meet this H&W requirement. So let's just provide a couple of illustrations to how to discharge your obligations here. So let's start with the easy one, with the odd number. So again, the current requirement is $4.54 an hour, or $181.60 per week. So let's say you provide to an employee health insurance at the rate of $3.50 an hour. So you're paying out of pocket $3.50 per hour for an employee's health insurance. You also contribute to their 401k at the rate of $1 an hour, and then you provide a cash payment to that individual of 4 cents an hour. And again, that's outside of their normal wages. It's reported separately on their pay stub. So in total, you're contributing H&W at the rate of $4.54 an hour to that employee, and that would satisfy your health and welfare requirement if you have an odd numbered wage determination. So jumping over to the even number, again, the H&W requirement is $4.54 an hour, or $181.60 a week. Let's say you have 3 employees. So for employee 1, you provide them $4.50 an hour in health insurance. Employee 2, you provide $4 an hour in health insurance and $1.50 an hour towards their 401k. Let's say employee 1 elected not to have a 401k or any contribution for whatever reason. And then employee 3, they declined health insurance because they're covered by their spouse, but they elect to have $3.75 per hour contributed by the employer towards the 401k. So this brings your average, for your average H&W in total, per hour, you're providing $13.75 in total H&W to these 3 employees. When you divide that by 3, that gives you a rate of $4.58 an hour. So you've satisfied your H&W requirements with a little bit in excess for an even numbered wage determination. And let's say you did the math, and the numbers are a little bit different, and your average came out to, let's say, $4.48 an hour. You would then need to pay cash to each of these 3 employees to reach that $4.54 an hour. And if it's $4.48, $4.54 minus 48 is 6 cents an hour. You would essentially give each of these employees 2 cents an hour in cash equivalents to reach that hourly rate. So it can be some relatively complex mathematical calculations, but it is an important thing to keep an eye out for, again, is the numbering of your wage determination. The other important thing to remember for an even numbered wage determination is that you don't have to provide the same amount of H&W to each employee, as long as, on average, you're at $4.54 an hour. Typically, under what we see for an odd number wage determination is that if you pay one employee the minimum rate, but then you pay a second employee in excess of the minimum rate, from an equality perspective, the Department of Labor would expect you to then essentially true up that first employee so that they're getting the same monetary contribution from you as that second employee. So you would need to make up that difference by providing the first employee an additional form of H&W benefits, whether it's in cash payment or through other forms of bona fide fringe benefits. That's not required if you have an even number determination. So as if paying fringe benefits, prevailing wage, and providing holidays isn't enough of a headache, there are a number of record-keeping requirements that go along with the SCA as well, where you're required to maintain specific records for all covered employees for at least 3 years. These include personnel records, so they contain a name, address, or social security number, documentation of the work classification, the wage rate and fringe benefits provided for the contract work. This includes any list of conformance wages and fringe benefits. That way the Department of Labor can monitor whether or not you properly classified each position on the contract. The total daily and weekly compensation, a number of daily and weekly hours worked, and then any deductions, rebates, or refunds from compensation. And again, these records need to be maintained for at least 3 years. And when you're recording the total and daily and weekly compensation, again, if you're providing a cash equivalent for H&W benefits, that needs to be listed out separately from the employee's hourly wages. So, another kind of odd requirement, that goes along with the SCA was under Executive Order 13495, where this was the non-displacement requirement for covered service contracts. And what this said was that, if a successor contract for the same or similar services at the same location as a prior contract, if you have that successor contract, you're required to offer the predecessor's SCA covered employees a right of first refusal for positions in which they are qualified. So essentially, you have to provide those individuals the opportunity to come work for you and continue working on that SCA covered contract, and going along with that, continue their seniority and their related vacation entitlements and all that jazz. And again, the requirement applies to positions for which predecessor employees are qualified and positions that will perform work that are covered by the SCA contract. It doesn't apply to non-SCA employees. So I mentioned, this was something they needed to worry about. Fortunately, in November, the Trump administration actually revoked the non-displacement requirement. So this is no longer something that you need to worry about, at least for the remainder of the Trump administration. If a new administration comes into power, we could see the non-displacement obligations come back into play. But for now, it's for informational purposes only, and it's not something that you currently need to worry about. So I know those are a lot of obligations, from an SCA perspective. Let's talk about why it's important, to make sure that you come into compliance. And I'm going to turn it over to Joe Berger in DC to really go through, what are the different, compliance-related issues and what are the consequences of non-compliance. Take it away, Joe.
Thank you, Matt. And I'm here in DC with my colleague Tom Mason, who's head of the Government Contracts Practice Group. And I'm going to talk just a little bit about the consequences of non-compliance. Of course, we want to avoid non-compliance, and we want to do that through proactive efforts to achieve compliance. That's the goal, but it's good to be aware what the consequences of non-compliance may be. Under the statute, the Service Contract Act, those can include payment of back wages, withholding of progress payments, cancellation of a contract, payment of costs to the government, personal liability for corporate officers, and suspension and debarment. And again, of course, we want to avoid all of these consequences, and the way to do that, the best way, is through proactive compliance. Next slide. And here's an example from DOL, a news release from Department of Labor last year concerning a company in California, which was required to pay $3.5 million to 1,400 employees after the Department of Labor, the Wage and Hour Division, found that the company had violated the SCA. Next slide. The WHD investigators had determined that this company had violated the SCA by failing to pay prevailing wages to the employees who were performing work at a customs facility at the Port of Los Angeles. And interestingly, as noted in the middle bullet, the investigators also found that the company had failed to apply the SCA clauses to subcontractors, which resulted in the subcontractors' failure to pay the prevailing wages to their employees as well. Prevailing wages and fringe benefits to their employees. Next slide. The Department of Labor recently has announced a new pilot program for discretionary suspensions and debarments. This is an indication of increased enforcement efforts. And a discretionary suspension can be for 12 months, a discretionary debarment for 3 years, and the pilot program involves increased coordination between DOL and its Office of the Inspector General. Next slide. And that is in addition to a statutory prohibition which would apply in the event that that there is a finding by the Department of Labor through an administrative hearing that there was a violation of the Service Contract Act. If that's the case, and again, we want to avoid consequence of noncompliance, but if that's the case, if there is an administrative finding by DOL that there was a violation of the SCA, then this statute, the three-year prohibition on new contracts would apply. And that information is distributed throughout the government. Matt, can we go back to the previous slide? In addition to that 3-year prohibition, in the FAR clause, this FAR clause, you'll see there's a paragraph P, which has a contractor's certification, which says by entering into this contract, the contractor certifies that neither it nor any person or firm who has a substantial interest in the contractor's firm is ineligible by virtue of this statutory prohibition. In addition to that, no part of the contract can be subcontracted to any person or firm that's ineligible. And this certification automatically applies anytime this FAR clause is in the contract, which leads us to the next slide and the False Claims Act. This is a worst case scenario, but again, we want to be aware that it can apply. And the FCA can apply to allegations of violation of the Service Contract Act, in addition to allegations of violations of other statutes and regulations. And just to explain how that can be, the relators or whistleblowers can allege that an employer fraudulently reported to the government that it was in compliance with the SCA. In these cases, these are just a couple of examples. The SCA does have a bar on private rights of action, but that does not preclude a lawsuit under the False Claims Act. Next slide. This is just another example. A recent decision earlier this year. Here, the whistleblowers are former employees, a tractor trailer driver and an equipment operator of the defendant who is a demolition contractor. And the whistleblowers are alleging that there was a violation of the False Claims Act by contractor, the subcontractor, and the subcontractor's owner, alleging that they violated the FCA, defrauded the government by failing to pay the prevailing wages mandated by the SCA, and at the same time submitting statements, claims for payment, and certifying compliance with the statute. Next slide. So that's the worst case scenario, which of course we want to avoid. And when discussing the False Claims Act, we discussed the mandatory disclosure rule, which is closely related. And it's present in contracts above 5.5 million and subcontracts, and required to flow down in subcontracts. So contractors should expect to see this clause. Next slide. And the clause contains the requirement for a written code of business ethics and conduct available to each employee engaged in performance of the contract. And it also requires, with certain exceptions, an ongoing business ethics awareness and compliance program and an internal control system, the standards for which are set out in the clause. And the MDR was added more than 10 years ago. It includes the requirement to disclose to the government when there is credible evidence of a violation of certain criminal laws or the Civil False Claims Act. And again, it's a worst case scenario, but it's something that you always need to keep in mind. And that leads us to the conclusion. Matt, last slide. The conclusion that the best practices require robust compliance with not only the MDR, but federal acquisition regulation, the statutes, regulations, and contractual requirements, and the company's code of business ethics and conduct, and with the Service Contract Act, and all of which is simply a reminder that the best way to avoid these consequences of non-compliance is to make proactive efforts to achieve the best compliance possible, which leads us to common pitfalls. Matt, you want to take those?
Thank you very much, Joe. So yes, obviously everybody, a lot of scary consequences and potential penalties for not complying with obligations under the Service Contract Act. A few notes I just wanted to make about what Joe mentioned was first, his summary of the case law where a claim under the False Claims Act is not barred by the SCA's prohibition on a private right of action. So what the SCA says is that an employee who believes that they're not being paid the prevailing wages or fringe benefits can't file a lawsuit in court. What they would need to do is instead they would file a complaint with the Department of Labor's Wage and Hour Department, and then you would have a wage and hour investigator come knocking at your door, flashing their badge, and undertaking a comprehensive audit of your business and your contract compliance. Another thing to note is the FCA actions for making false certifications of compliance to the government. That's not limited solely to compliance with the Service Contract Act. In several of our prior webinar installments, we talked about a number of other compliance issues or compliance obligations and issues such as affirmative action, equal opportunity, EEO1 reporting, and stuff like that. And I'll be touching on those in a few minutes here today as well. Those are all things that could also lead to a False Claims Act lawsuit through non-compliance, where if you enter into a government contract, you are certifying in that contract that you're complying and have with the affirmative action obligations, you have affirmative action plans in place, you're filing your EEO1 and required BETS reports. Those are all things that you're certifying to the government in addition to any potential wage and hour obligations. And if you certify and aren't actually complying, that's where you can get into the issue of a False Claims Act lawsuit being filed against you. So that's just an important thing to remember, is that the potential liability under the FCA is not limited to Service Contract Act issues. With that said, and with those consequences in mind, what are some pitfalls that we typically see from a compliance perspective? First and foremost, kind of touching on the first part of what we spoke about today, is failure to determine applicability or coverage, where you don't know that you're covered by the SCA until the government comes knocking at your door and telling you that you are, and then laying out how much you're required to pay. Another issue we see is contracts contain the SCA clause but are missing the wage determination. Again, even if the wage determination is not in the contract, if the contract itself is covered, the DOL is going to expect you to comply with the SCA. I mentioned earlier, there are, some protections for employers in this situation where if it doesn't contain a wage determination and you're found to have not paid the necessary prevailing wage, part of that fault is going to be assigned to the contracting agency, where you're still going to have to make the back wage payments to employees, but it may mitigate any penalties, and you'll also be entitled to an upwards price adjustment of your contract with that contracting agency to make up the difference. So that's one of the things that is supposed to go into the contract negotiation process, is a requirement to pay prevailing wages, which are typically higher than what you would normally pay an employee for the services being provided. And so if you have no idea what those wage rates are because the government agency forgot to include the wage determination, that's something you would be able to take back to them and get an upwards price adjustment, essentially retroactive to when you were supposed to comply. Another pitfall area is, again, applying the wrong wage determination. Is the work being performed in Cuyahoga County, Ohio, up here in Cleveland, but for whatever reason, you apply a wage determination for Columbus, Franklin County. Or there could be an issue with the geographic location. Or another one you see again is that distinction between an odd versus an even numbered wage determination, and the differences, in how you calculate H&W benefits. A lot of times, if you're paying an excess of the H&W rate anyway, that could be turned into a non-issue, even if you were applying the incorrect wage determination. But it could still be something that could present a compliance issue, and it's something to keep an eye out for. Another issue we see is mapping employees to incorrect labor classifications. So again, not using the directory of occupational titles to make sure that you're matching the position to the most closely aligned labor classification and description in those guidelines. Again, this is something that would typically come up in a wage and hour audit or investigation by the Department of Labor. This could also be something that could go along with improper classifications for exempt or non-exempt status, where again it goes back to coverage. Improperly classifying employees as exempt when they're truly non-exempt, that could lead to issues under the SCA as well. Having employees perform multiple functions or switching roles mid-contract, if you have them performing multiple functions and the functions they're performing fall into two separate labor classifications with two different hourly rates, the time spent performing one function would need to be paid at one hourly rate, and then the time spent performing that other function would need to be paid at a separate hourly rate. That's why it's important that, to the extent possible, the employees you have working on this contract should only be slotted into one particular labor classification. And if they do switch roles during the contract, make sure that's documented and make sure the necessary changes and adjustments are made to their compensation. And so, if you have a situation where you have someone being paid at a higher rate for their classification, then they downgrade in classification mid-contract to a lower rate, they should then be paid that lower hourly rate. That's unfortunate for the employee, but that's what's required under the contract, because otherwise you'll have that individual being paid at a higher hourly rate than the other people in that same labor classification. That could lead to compliance issues from an SCA perspective. Another issue we typically see is from record keeping, is failing to separate wages or fringe benefits on pay stubs. Important thing to remember here again is if you do cash equivalents to meet your H&W requirements, those need to be laid out separately on a pay stub. Same with any fringe benefits provided versus the hourly rate. As well as another issue we see is performance location versus the governing wage determination. So here, the issue is if you have remote employees, let's say, they're situated in Ohio, but the contract that they're supporting is in Florida, they would need to be paid according to the governing wage determination, not the wage determination that would apply to where they sit in Ohio, but where the services and the contract is being performed down in Florida. That would be the applicable wage determination. And finally, issue we see is subcontractor compliance. So if you're higher up in the chain and you've contracted with another organization to perform some of those SCA covered services, you as the higher tier contractor are responsible to a certain degree for making sure the subcontractor complies. And if they're not, that can present issues for both you and that subcontractor. So how do we avoid these issues? It starts with always asking questions. There's never a stupid question when it comes to SCA or legal compliance in general. So this starts during the bidding process. You want to start the dialogue with the contracting officer, with whatever agency that you're working with, to make sure that you're getting all the information that you need, to not only make sure that you take proper steps to comply out of the gate, but also so that you can price, and bid the contract accordingly. Again, if you know you have to pay prevailing rates to employees, that's something that will go into the price that you're going to want to bid, and that the contracting agency may be willing to pay for those services. If the work appears to be SCA covered, so if you are talking to the Department of Defense to provide janitorial services on a military base, that's something that's going to be covered by the SCA. But the documentation you have has no clauses in them or other indicators. You need to request clarification from your agency contact or your higher tiered contractor, to make sure that, are we covered by the SCA, and if so, what steps do we need to take to comply? Another thing to look for is if the contract has a SCA clause but does not have the wage determination, go back to that agency contact or that higher tier contractor and ask for it. It's their obligation to provide it to you, and if they're not willing to do so, that might raise a question in your mind as to whether or not you want to do business with them. Then also ask for detailed descriptions of the work to be performed. This, again, will help you determine coverage or non-coverage, as well as help you properly classify employees for prevailing rate purposes. So the next step to do after you ask those questions is, and you get the wage determination in your hand, is you want to review both of those documents, both the wage determination as well as your labor classifications. So it starts with, again, looking at the wage determination. A, make sure you have the correct wage determination. B, what is it, an odd number or an even number? And then C, just to identify the other applicable requirements, as well as to initially identify potential classifications for your employees and your positions. You should then prepare written descriptions of the duties performed by each group of employees that are going to be working on the contract. Then take those descriptions and compare them against the classifications in the Directory of Occupational Titles to determine the best mapping for your employees and the best classifications. The thing to think about here is, can the work be performed in a lower level labor category with a corresponding lower wage rate, or is more experience in a higher classification required? If the work can be performed in a lower labor category, and you're able to slot employees in there and their job descriptions match, that could make you more money on the contract at the end of the day. So going along with those classifications is document. You always want to maintain complete documentation of all decisions regarding these classifications in case the issue ever comes up, or if the Department of Labor comes knocking and wants to see how you classify those individuals. If a conformance is required, make sure you document that entire process from your initial analysis to your formal request submitted to the Department of Labor. I'd also recommend engaging legal counsel to assist you in the conformance process and help you determine how to make the conformance request and what hourly rates to tie to those individuals. And again, if employees perform multiple functions or switch jobs mid-project, again, you want to have steps in place to actively track and document the transition or switch in function, as well as any related adjustments to compensation or job duties. Another thing you can do is, again, you want to actively examine your payroll and monitor your payroll and benefits practices. And the questions you got to ask yourself here are SCA employees being paid according to the governing wage determination? If the answer is no, then that's a red flag that needs to be dealt with immediately. You want to review all benefits that provide to your employees. You want to make sure that are they bona fide under the Service Contract Act. So they may be, you may consider them to be a benefit under company policy, but would they be considered a bona fide fringe benefit under the Service Contract Act and count towards your H&W requirement? You want to do the math. Are you providing enough H&W benefits? Again, this goes to, knowing that if you have an odd versus even numbered wage determination. if there are, from an equality perspective, if there are pay differences between two employees in the same classification, again, can this be explained? If the answer is no, then some changes need to be made. And are wages and H&W benefits, including cash payments, reported separately on pay stubs? Again, this is a specific requirement under the Service Contract Act, and is something that should be done from a record-keeping perspective. And finally, monitor your subcontractors. Remember, if you're the prime contractor or the higher tiered sub, you are responsible for those below you. You want to make sure with your subcontracting relationships, with your contracts, that you include all the required clauses as well as the wage determination in the subcontract. You want to make sure that your subcontractor understands the requirements and their obligations at the outset of the relationship. If they're unwilling to undertake those responsibilities and those obligations, that's a pretty good indication that you probably don't want to engage them to perform that work for you. Another thing you can do is establish a schedule for periodic check-ins on your subcontractors, where you send them a letter and you request the appropriate documentation of compliance, including payroll records, labor classifications, and stuff like that. This almost functions as your own informal SCA audit of your subcontractor. And again, because you're responsible for their compliance to a certain degree, it's well within your right as the higher tier contractor to request this information and to make sure that they're in compliance, because you don't want to be caught blind with the government coming in and auditing that subcontractor, find they're not in compliance, and then coming to you and asking you why you did not take steps to make sure they were compliant. So this is something you can do as part of the monitoring process to make sure that they're doing everything that they need to do. So I know that was a lot of material on the Service Contract Act, and we have about 20 minutes left here today. So I just wanted to kind of change gears and talk about what are we looking ahead to for the new calendar year in 2020, and specifically what can we expect outside of the SCA, but with the Department of Labor's other organization, the Office of Federal Contract Compliance Programs, which, as you know, is the organization responsible for monitoring and enforcing affirmative action compliance with government contractors. So first, let's talk about what happened in 2019 with OFCCP. So on March 28th, the OFCCP released their annual corporate scheduling announcement list, where they identified 35 individual companies and facilities for full compliance evaluations, your traditional desk audit, Section 503 focused reviews, where they do both a desk audit and come on site to monitor disability compliance, or a more limited compliance check, where they just require you to submit documentation that you're actually complying with affirmative action requirements. Well, on November 8th, OFCCP released their supplement to the scheduling list, where they added 500 additional companies and facilities for now a VEVRA focus review, where this is similar to Section 503, but it's a specific focus on affirmative action compliance for protected veterans, where they're going to request documentation as well as potentially come on site out of the gate to make sure that you as an employer are meeting your obligations for affirmative action for employees and applicants who qualify as protected veterans. So obviously we're talking about 4,000 different potential audits from March 2019 and moving forward. So where are we currently? So actually on November 15th, the OFCCP Deputy Regional Director for the Midwest region, which includes Ohio, Indiana, Michigan, basically most of the Rust Belt states, provided an update during a conference in Indianapolis, where they noted that there were 111 Section 503 focus reviews scheduled in the Midwest region, or that were identified in the Midwest region, but only 20 had been scheduled so far. So, for you as an employer, if you showed up on that list back in March, but haven't gotten a letter from the OFCCP yet, you're not off the hook yet. They're still working through everything. They're known for having a huge backlog of audits and typically don't start new audits until they close out, audits from the prior year or even prior 2 or 3 years. So if you weren't one of those 20, you're amongst those remaining 91, you're not off the hook yet. there's still a pretty good chance that you're going to be getting a focus review in the near future. And this applies nationwide. We're talking about just the Midwest region here. You know, for the other remaining of the 500 in the other regions, it's a similar number that we're seeing, that the vast majority of these focus reviews have not been scheduled yet and are going to be coming down the pike at some point. They also provide an update on the Weber focus reviews, where 104 of these were identified in the Midwest. The OFCCP doesn't even expect to start these until mid-2020. So yeah, these were just rolled out, but they're not even talking about starting them until the middle of next year. So again, if you showed up on that list, the obligations and the potential for audit does not end at the end of the calendar year. This is an ongoing process, and the OFCCP is not afraid to drag things out and audit companies a year or even a year and a half after they showed up on the list. And then from the more traditional perspective, the traditional compliance desk audit reviews, there were 700 identified out of the 3,500 in the Midwest region, but as of November 15th, only 300 had been scheduled or completed. So there's still 400 out there that have not even been set up to start the audit process yet. And again, this is something that we've seen nationwide, where the OFCCP has only launched a fraction of audits against companies that showed up on the list. And just because they haven't audited you yet does not mean it's not going to happen. So this tells us that the two things: the OFCCP has a huge backlog, but B, they're also going to continue auditing based on that list for the foreseeable future. So this is something to keep in mind, and just to realize, you're not off the hook yet if you showed up on the list. If you haven't been audited, there's still a good chance that you're going to be in the coming months. Let's look at another statistic here from OFCCP. Fiscal year 2019 was actually a record year for the agency, where they actually issued 144 separate conciliation agreements, which, conciliation agreements are the settlement agreement that the OFCCP will try to enter into with any organization that they find not to be in compliance with really any form of affirmative action obligations, whether it's a technical violation or more substantive discriminatory issues. 56 of those agreements involve financial penalties. These are where the OFCCP came in and found, actual signs of discrimination, usually from a hiring or a compensation perspective, as part of the compliance audit. The remaining conciliation agreements were for more of those technical violations, so record-keeping issues, stuff like that. I mentioned it was a record year. They issued a total of about $40.5 million in back pay or financial penalties in fiscal year 2019. This was $16 million higher than the prior record year in 2017. An interesting thing to note is that fines collected over a 3-year period from 2017 to 2019 exceeded the prior 7 years combined of what was collected by the OFCCP. So what this tells us is that a lot of the expectations for the OFCCP that really came out when the Trump administration took office really haven't come to be. A lot of people thought that the OFCCP was going to scale back in their enforcement efforts, and they're actually ramping up their enforcement efforts and definitely increasing the number of conciliation agreements and violations that they look for. And so this signals us this train's not going to stop going into 2020. It's going to keep going, and it may turn into really a runaway freight train from an OFCCP perspective. And this really hammers home the importance of taking steps now to come into compliance and make sure that you're on a solid footing going into 2020. So what are some other changes we're seeing from the OFCCP? It starts with the scheduling letter for the desk audit, where the OFCCP is now going to be asking for information about any subcontracts that you have straight out of the gate with the initial desk audit request. Or they're going to add a new line to their desk audit letter where they're going to request you to provide a list of subcontractor names and locations of the 3 most recently awarded subcontracts that have a total value of $150,000 or more, excluding those expiring within the 6 months receipt of this letter. What to us this signals is the OFCCP's intent to expand the scope of their compliance jurisdiction to additional companies and organizations. And there's a method behind asking for that $150,000 threshold, where if you have a subcontract where you're paying someone $150,000 to provide something related to your government contract, that $150,000 is one of the thresholds for compliance with protected veteran affirmative action under VEVRA. So there's a method to that madness. They're also, not interested in anything expiring within the next 6 months because, they want to look for long-standing relationships or new subcontractors, because that's the way that they can expand their jurisdiction and capture those additional companies and potentially schedule them for audit down the road. And we could also see, going along with this request, as the desk audit proceeds, them wanting you as the higher tiered sub or the prime contractor to obtain proof of compliance from those subcontractors below you. Because again, if that subcontractor is doing work related to your government contract, they independently have their own affirmative action obligations, and you as the higher tier contractor may have some responsibility for making sure that they comply. So that's, in our mind, is really why the OFCCP is asking for this information. Another thing the OFCCP is doing is they're seeking to revise everyone's favorite document, the Voluntary Self-Identification of Disability form, where in October of this year, they sought public comments on a number of proposed revisions to the form itself, where they would expand the list of disability examples to include heart disease, autoimmune disorders, non-PSD, psychiatric conditions, and gastrointestinal disorders. It removes the second page of the form, which contained the reasonable accommodation notice. It also adds additional disclosure language for applicants. It also adds an additional response option where traditionally you could respond as saying, yes, I have a disability. Well, that response now says, yes, I have a disability or have a history or record of having a disability, which really more closely aligns, the survey responses to, how the Americans with Disabilities Act defines, someone with a protected disability, which includes a record or history of a covered disability. Another thing the OFCCP is exploring is getting rid of the name line on the form and instead, requiring contractors to have another method in place to, track who is completing this form, whether it's through an identification number or otherwise. And really the method behind that is to, help persuade more applicants to actually complete this form and return it. Because one of the issues that we've run into is that a lot of times applicants are hesitant to self-identify disability or complete the form during the application process because they're asked to put their name on it, and applicants may feel, regardless of what the form says, that could be used against them during the application process. And so by making it almost a blind form and having a different tracking method, the OFCCP sees that as a way to hopefully help alleviate that concern and get more responses from applicants. So obviously this revised form, can present some headaches if you create an electronic version of the form and roll that into your online applicant tracking system, where that in our experience has presented a number of different issues from a technology perspective, as well as meeting the OFCCP's specific requirements for language and format. Well, the headache there is that you just finished doing that, or finally got that into place, and now you're going to have to change it and go back in and redo everything to make sure the updated form is in place. We expect this form to get rolled out at the end of January or early February because the current form expires on January 31st. So this is something to keep an eye out for. Another thing we saw was OFCCP has already issued their first directive for 2020, where they're expanding the scope of their review during a compliance evaluation to ensure non-discrimination against spouses of protected veterans. And this will typically come into play during an on-site audit. So this will probably include during a VEVRA-focused review, where the OFCCP officers are instructed to ask a number of different questions during employee interviews. These include, are they a spouse of a protected veteran? Do they have coworkers who are spouses of protected veterans? Have they had any observations or concerns regarding treatment of protected veterans or spouses of protected veterans at work? And during management interviews, the members of management will be reminded of their duty not to discriminate against spouses of protected veterans, and the OFCCP will also bring a copy of their sample policy and offer it to you to incorporate into your own handbooks or your own policies to ensure non-discrimination against spouses of protected veterans. So this tells us is that if they ask for a copy of your handbook moving forward, they're going to expect to see spouses of protected veterans included as a category of protected employees in your non-discrimination policy. So yeah, obviously these are a number of different changes from the OFCCP, as well as just a good outlook on what we expect from OFCCP from an enforcement angle. So what can you as a contractor do? It starts with preparing your 2020 affirmative action plans. Obviously you still have a little bit of time to the end of the year, but it's something to start thinking about is, get the ball rolling to make sure that you can start getting your plans in place once January 1st comes around. And this applies to all three of your affirmative action plans for females and minorities, disability, and protected veterans. Again, the thing about is the numbers. You're required to prepare an individual AAP for each location with at least 50 employees. If you have less than 50 employees, you have a few options. You can either roll it into your corporate HQ, or you could create an individual AAP for that location. And again, the key thing to think about is if you're audited by the OFCCP, you want to separate that target facility from any other facilities that may be rolled up into the plan. So if your corporate location gets hit with a Section 503 focus review, OFCCP is going to ask for a copy of your affirmative action plan. If you roll remote employees or smaller locations up into corporate, you'll want to remove them out so that the OFCCP can't then extend their jurisdiction and the scope of their audit to those smaller locations, and they're cabined only to your corporate headquarters. You should also, this is a good opportunity to review your applicant tracking procedures. Again, self-identification surveys, you want to make sure that they're all up to date, specifically the one for disability. And you want to make sure that you're conducting these surveys both pre-offer as part of the initial application, as well as post-offer, so as part of the onboarding process for new hires. You want to make sure that you're properly tracking your submissions and dispositions of all applicants. You want to make sure you have a date an application is submitted, and make sure that all applications are being properly dispositioned. Because during any compliance audit, the OFCCP is going to ask you for an applicant log, and they want to see specific reasons listed for why particular individuals were not selected for opportunities. You also want to review your supporting documentation. Are you maintaining and do you have copies of job applications and resumes, self-ID forms and responses that are actually completed, interview notes, testing results, if any, make sure those tests are scientifically validated, as well as you want to make sure you have documentation of all hiring and onboarding materials that you use as part of your process. Another thing to think about here is you want to consider conducting privileged self-audits. These are actually specifically required under the affirmative action obligations, and they fall into really three different buckets. Personnel practices, so hires, promotions, and terminations. These are what we traditionally call the adverse impact analyses. You want to look at your compensation systems. This is, I'm sure you've seen in the media, and if you tuned in back in May, I talked about pay equity audits. This is the pay equity analysis, where the OFCCP expects you to conduct a proactive periodic audit of your compensation systems to make sure that employees of protected classes are not being disparately impacted from a compensation perspective. If you get audited, the OFCCP is going to ask for specific employee level compensation data, and they'll then conduct their own statistical analysis and audit of that data to identify potential issues. So really here, the advantage is if you conduct this proactive audit, you're going to know ahead of time what the OFCCP is going to find anyway, and then you'll be able to take steps to implement any necessary changes to then be able to show the OFCCP, yes, we detected those issues, here are the steps that we're taking to make corrections and to prevent that from happening in the future. And then another thing you want to make sure you are actively auditing are your recruiting and selection procedures. Again, are are all protected classes fairly represented in your applicant pools? If the answer is no, then that could be an indicator that you need to make some changes to your recruiting and selection procedures. This is another thing the OFCCP asks for in connection with any audit is documentation of those audits of your recruiting and selection procedures, as well as an outline of any changes that were made. So these are all things that you should consider doing in the new year, and to then make sure that you're in the best possible compliance position should the OFCCP come knocking. Then the last thing is, again, check your affirmative action record keeping. The new thing to keep in mind here is make sure you have copies of your most recent subcontracts, regardless of location. Again, in an audit, the OFCCP is going to specifically ask for those documents. You want to make sure you have them on hand and know what's in there, so that's you're best prepared to respond to the OFCCP, and you're also aware of any potential issues. You also want to make sure that you are keeping all personnel records for at least 2 years, and then certain self-assessments are being kept for at least 3 years. These are, again, your self-assessments of your outreach and recruiting efforts, your personnel policies, particular hiring benchmarks and utilization goals for veterans and disabled, as well as the required data analyses for annual veteran and disabled applicants and hires. That's all stuff that you need to be collecting. If you haven't, you should start doing so in the new year. And you also want to maintain that documentation for at least 3 years. So as if that's not enough to worry about, to kind of wrap things up here, I just want to talk briefly about your annual reporting requirements. Believe it or not, despite all the publicity and the attention, yes, the EEO1 Component 2 pay data reports are still alive and kicking. The EEOC, in an agreement with federal court, has agreed to extend the reporting window through January 31st of 2020. As you know, the original deadline was September 30th. So if you have at least 100 employees or you're a government contractor with at least 50, and you haven't done so already, you should file these Component 2 reports. And this includes reports for both summary pay data and aggregated hours work data for all employees in your U.S. workforce. Where again, this information needs to be broken out into 12 different salary bands, as well as split out between particular, each individual EEO1 job category, as well as, this EEO1 gender and race and ethnic categories as well. It's a headache to do. If you were like me in September, the month of September was a pretty miserable experience. It's a lot of number and data crunching, but it is something that's still active. If you haven't done so already, you should take steps to do so before January 31st. And certainly, happy to answer any questions about specifics of completing this process. And we've also seen, important thing to note here, EEOC investigators are requesting copies of these reports during new discrimination investigations. So the EEOC is actively monitoring this. The OFCCP has come out and said they're not going to be asking for this information either during a desk audit or from the EEOC directly. So you're at least in the clear there, but the EEOC is seeking this information during discrimination investigations. And then finally, last but not least, annual thing to think about and remember are your 2019 EEO1 Component 1 reports, the traditional reports. These are currently due March 31st of 2020. Now, obviously, last year the deadline was extended due to the government shutdown. There's no indication that the government's going to shut down again between now and March 31st, but again, anything could happen. But the date to keep in mind at this point is March 31st of 2020. And the action items that you should start thinking about here is first pick a payroll period between October 1st and December 31st. And then for each location, collect gender and race and ethnic data on all employees in each EEO1 group who worked for you at any point during that particular payroll period. So it's not just a snapshot of employees who worked for you at the end of the payroll period. If you pick October 1st through October 14th, you need to collect this data for anyone who worked for you during that, at any point during that payroll period. Another thing to think about, if you've acquired, merged, sold, or spun off a company in the last year, this is something you'll need to notify the EEOC of so they can properly document that in your system. And this may also require some adjustments to how you structure EEO1 reports. And then if you have any employees who currently don't have race or gender information in your system, you'll need to take steps to obtain this data from alternate means. These could include sending a resurvey for self-identification information, looking at employment records to see if you can identify it if there are other means, and as a last resort, reaching out to your supervisor, hiring managers, and getting an estimate based on a visual observation. That's the last option. You should try the resurveys or the other documentation first. At the end of the day, if that doesn't work, you can go to the visual observation, and for your reports, you do need to collect this information for each and every one of your U.S. employees who work for you during your designated payroll period. So I know that's a lot of information, a lot to think about. As we near the end of 2019 and roll into 2020, I think we're a little bit over, but I'm certainly happy to answer any questions from anyone at that point. If you do have any, please enter it in your box now. I'll give you a few seconds to do so. If there are no questions, then if you have anything or want to ask any questions offline, please don't hesitate to reach out to Joe or myself or any other member of our team. But I think on behalf of Thompson Hine, I would like to thank you for joining our webinar today on the Service Contract Act as well as the 20 Outlook. And I'd also like to wish each and every one of you a wonderful holiday season. I look forward to reconvening with you again in the new year. So thank you very much for attending.
Thank you, Matt. Happy holidays.